Remain seated. All right, we'll go back and take up the next case of Wellington Retreat versus Kathy Hutchings.
Yes, Your Honor. Please the court. My name is Jim Tellerman. I represent Wellington Retreat, Inc. in this appeal. I'd ask the court to allow me 5 minutes for rebuttal, please.
Okay.
On its face, this sure looked like a very, very simple appeal. We're dealing with a very short 2-paragraph contract. We're dealing with a very short 2-sentence statute. And there are really no issues of fact that the court has to deal with today. I can't speak for my colleague, but certainly as I got further and further into it, this became a very interesting case. And I think, at least in part, it presents a question of first impression, at least in this district, with respect to the construction of Section 57.1057 of the Florida statutes. I think that's where I'll begin. The case itself was fairly straightforward. The appellee brought a lawsuit, later asked to amend that lawsuit for the specific purpose of including an attorney's fee claim in the litigation. That attorney's fee claim being based on a written contract which was attached to their amended complaint. They persisted in the case for a number of months thereafter, never withdrew the attorney's fee claim or asserted that the attorney's fee claim was somehow put in the case by mistake, and ultimately voluntarily dismissed the case. There's no dispute that that voluntary dismissal made my client the prevailing party below, and we filed, therefore, an attorney's fee claim before the trial court. We're here today because the trial court, we believe incorrectly, denied our attorney's fee claim. Part of that attorney's fee claim is based upon 57.1057 and how that statute should be constructed. And this case is kind of interesting because the facts are kind of backwards, if you will. In other words, it's the defendant that initially raised the attorney's fee claim. And the real question is whether by raising that claim, depending upon how you construe the contract, if you construe the contract as limiting attorney's fee claims to collection matters only, does the contract and the defendant's invocation of the statute expand the scope of an attorney's fee claim to anything, quote, with respect to the contract?
Your client is the one who drafted the contracts and could have included prevailing parties entitled to fees, period.
Right.
Correct? But chose to limit it to just prevailing party in, well, not prevailing party, us in a collection case.
Not necessarily.
Wellington in the collection case, or legal things to collect the money. I mean, wasn't it all related to collecting money under the financial side? Because there were 2 agreements, the client's rights agreement, and then the I'm responsible to pay you guys agreement.
I think that general statement is accurate. But how you construe the contract, I think, is open for discussion, simply because certainly the statement of financial responsibility was focused on money. I don't think there's any question about that. But the language in the contract does discuss collection or legal action. I didn't draft the contract. I'm sure it's not the most elegant contract that's ever come before this court. But if we're going to give the contract meaning, one would think legal action is not the same as collection, or those words wouldn't be in there. So does legal action include defense of a case where the patient, if you will, has brought a case to recover monies that have been prepaid? I suggest that the answer to that question is yes. If anything, Your Honor, this is kind of a reverse collection.
Well, but with legal action, it says, should the above-named patient default on or become delinquent in payment of fees, it may and should become necessary to pursue collection or legal action. So the legal action there still relates to the idea that the patient defaulted or became delinquent in the payment of fees.
I think it relates to money, there's no question about
This
it.
case wasn't a situation where she was delinquent in payment of fees.
Well, again, as I said at the beginning, this is the mirror image, if you will, in that the appellee brought a claim to recover prepaid fees, sort of a reverse of a collection action. In other words, instead of the Wellington Retreat suing to get money, the appellee was suing to get money. Does that fall within the ambit of the specific contractual language that we've just been discussing? I think so.
What concerns me here is the idea of you getting the benefit or arguing for the benefit of, so as to expand the meaning of this provision. By that I mean, if your client sued for collection of fees and prevailed, you'd be entitled to attorney's fees. If your client sued for something else and prevailed, would not be entitled to attorney's fees. And now here you're arguing that because they brought an action, even though it fits into not a collection of fees case, that should somehow expand this provision for your benefit when it's your client that drafted this limiting language.
Then I certainly understand your concern, and I don't deny the legitimacy of that concern. But that's where we get into the statute. And if you look at the 4th District's Platina decision, a 6-5 split in an en banc case with 2 dissenting opinions, I think that sort of crystallizes the argument on both sides of this argument. With respect to my side, I think the dissent in that case stands for the proposition that first and foremost, 571057 changes contracts. It expands, it goes beyond what the parties intended when they signed a contract.
Well, it makes them reciprocal.
It makes it reciprocal, but then the argument in the dissent in Plantina is that it makes it reciprocal beyond, in a case like this, where, let's say, for the sake of argument, the fee issue is limited to a collection case in the language in the contract. The dissent is saying, based on the plain language of the statute, when it talks about any claim under a contract and a prevailing party with respect to any aspect of the contract, that the statute must be construed not only to expand and go beyond the intent of the parties with respect to unilateral attorney's fee provisions, but to basically make it an open-ended attorney's fee provision. And I would say, if the intent of the statute is to be carried out, which is to create a level playing field, and I don't think there's really a dispute about that, then the level playing field has to be expanded to any action related to the contract. And if you accept that construction, which the dissent in Plantina asserts, and I agree, is the plain reading of the statute, regardless of how we feel about that plain reading of the statute, then I think you have to rule for the appellant in this case.
Yeah, it struck me that the 4th DCA, the dissent, you had a different situation than here. You had the non-drafting party was the one seeking fees as opposed to the drafting party. And I think there's a recognition that, typical construction contract, the contractor says you owe me money, and the other side says you did lousy work. And the first person, if it was if the contractor brings the action to get paid and they prevail, they get fees, but the other side says we didn't pay you because you did defective work, or they sue for defective work, and they win, they don't get fees. So I think that's where, I know they relied on the language of the statute, but I think that was the policy concern, that as a practical matter, most disputes between contractors and, and homeowners or property owners is money versus workmanship.
Right.
and that you could get money on the, you could get attorney's fees on the money claim, but not on the workmanship claim. But, here, it's the drafter who's trying to, again, expand their provision. So to me, it's a little different in that case, even if you agree with the dissent, it's still factually different.
Well, let's say that the contractor had prevailed in Plantina. All right, it would have been the customer who invoked the attorney's fee claim based upon the collection language. All right. What if the contractor prevails? Would it be right to conclude that the statute expands the scope of the agreement, redrafts the agreement for the parties, only for the benefit of the customer? Or, if we apply the language, the simple, straightforward language of the statute, once the customer invokes the attorney's fee claim, albeit in language that appears to be limited to a collection case, and we're beyond a collection case, undoubtedly, and the contractor prevails, why should the contractor not be entitled to attorney's fees? Why should the playing field not only be made level, but made less than level by just giving the customer the benefit of the statutory language?
It wasn't the majority's decision to keep them level?
That it is, yeah. And that's the tension in this case. That was the tension in that case. There's no question about it.
So what's wrong with keeping it level by saying, if you sue for collection and you win, you get attorney's fees. If you defend against a collection action and you win, you get attorney's fees. But no one gets attorney's fees in anything other than a collection action.
But, well, is there anything wrong with that? The only thing wrong with that, well, first of all, that means I lose this appeal. That would not be a good thing. But looking at the bigger picture, Your Honor, I think it's contrary to the plain language of the statute. I do find...
But it's consistent with the language of the contract as far as the drafting party.
In that case, it's consistent with the language of the contract. But once you expand the language of the contract to allow for the mutuality on something, well, again, now I'm sliding into the dissenting opinion again. And I won't repeat myself. I think you understand my argument. But I would also call your attention, for what it's worth, to the unfortunately named jerk machine case that I cited to in the reply brief, where Judge Olson in the Southern District Bankruptcy Court was faced with a case where a fraudulent transfer claim was brought by a customer of a bank, and where that customer of the bank claimed attorney's fees under a promissory note. That was the only basis for attorney's fees, and was awarded those fees. The bank defended, among other things, by saying, wait a second, this was not an action based upon the promissory note, so you can't go beyond the specific topic of the promissory note attorney's fee provision to award fees in this case. And the bankruptcy court disagreed and specifically said, had the bank prevailed in this fraudulent transfer case, it would have been entitled to attorney's fees under 57-105 or parent 7, for the same reasons that I'm arguing, for the same reason that the dissent argued in the Plantina case. Briefly, Judge, in the time I have left, at least in this part of my argument, I just want to touch on the estoppel arguments that we also made. Again, it is undeniable that it is the appellee that raised the issue initially, that claimed an entitlement to fees, and then essentially said, oh, we really weren't entitled to fees at all. We never would have been entitled to fees had we prevailed, and essentially, never mind.
But doesn't estoppel require, especially judicial estoppel, require that you were successful in raising something? In other words, you got to win first before you were stopped?
Well, the case law seems to be all over the place on that issue, but again, my focus in this court is on this court's decision in the Philip Morris case, where the language is very simply, again,
Very familiar with the language.
okay, says it is a general rule the parties will be held to the theories upon which they secure action by the court. And
Which
in
was a big
pursu-
verdict by taking one position.
I beg your pardon?
Which in that case was a huge verdict by taking one position that you should find my client comparatively negligent.
Right.
But when it came time to entering judgment on the verdict, the same party said, no comparative negligence now.
Right.
So they took action and were successful by getting a huge verdict.
And in this case, the appellee took action by asking the court for leave to amend its pleadings in order to assert a claim for attorney's fees, was granted, albeit without argument. That leave stuck to its guns throughout the balance of the case, and then when the rubber hit the road and my client was before the trial court asking for attorney's fees, it said, nah, never mind.
No, I understand they flip-flopped.
Right.
I don't take that away, but the theory of estoppel, you have to get something of value first.
In the Philip Morris case, they got a tactical advantage with the jury. I mean, that's what the opinion of the court, of this court was.
And all I can say, and I don't think there's anything necessarily in the record to support what I'm about to tell you, so disregard it at your leisure, but to suggest that making attorney's fees an issue in a case doesn't change how a case is litigated is naive. And I do think that under the circumstances, concepts of estoppel apply for that.
Let me ask you one quick question.
course.
In the statute, it says the court may allow attorney's fees.
It does. But
What-
then
what-
there's a footnote in one of the cases, yeah, actually, I'm looking right at it, in the dissent in Plantina, that says despite the statute's use of the permissive may regarding the trial court's authority to award attorney's fees to the prevailing party, once the court has made the prevailing party determination, the award is mandatory, actually citing this court's decision in Holiday Square Owners Association, Inc. versus Setsenis at 820 Southern 2nd 450 from 2002.
Well, not everybody's following the plain language then, right?
Apparently not. And I'll save the rest of my time for later.
Thank you.
Thank you.
You may proceed.
Good afternoon, and may it please the court. My name is Ben Robinson of the law firm of Broad and Cassell. I'm here on behalf of the appellee, Ms. Kathy Hutchings. We agree with appellant that this attorney's fees appeal is fairly simple, and it boils down to the construction of one contract and the application or non-application of one statute. The relevant excerpt of the contract appears at the bottom of page 3 of the appellee's brief, and the relevant excerpt of the statute appears on page 15.
Let me ask you this, if we agree with the 5 dissenters, do you lose?
If you agree with the 5 dissenters in the Florida Hurricane Awning versus Pastina case, do I lose? No, absolutely not. If you were to agree with the 2 dissenting opinions, we still win because we are the non-drafting party. We are the only party that 57105 subsection 7 receives a benefit from the legislature, and Wellington is nothing like the non-drafting party, the recipient of the construction services in Florida Hurricane. If I may briefly return to the contract, the important contract here, as appellant mentions, is the Statement of Financial Responsibility, and I will occasionally refer to this as the SFR. Wellington points to the SFR for its contractual entitlement to attorney's fees, but of course, this is not a collection case, and because Ms. Hutchings' breach allegations pertain to an entirely different agreement, the client's rights document, the SFR provides no contractual base for Wellington to recover its fees.
Does the fact that the SFR includes a statement that no refunds for advance fee payments will be made in such cases where the client or the customer breaches the agreement, the fact that refunds is mentioned in that same agreement, is that enough to tie it back in and make it one of those, counsel used the term legal action?
No, Your Honor, it does not, because there are two explicit preconditions that would allow Wellington to recover attorney's fees if it were to institute legal action and recover those attorney's fees under the contract. And those two preconditions are default and delinquency. And neither of those preconditions exist here. Appellant points out that this case has no findings of fact, it did not go through trial, and there are very few stipulated facts. But there is one fact of record, one stipulated fact, and that is that Ms. Hutchings paid all of the expenses in advance associated with her visit to the Wellington retreat. So therefore, she was never in arrears, she never defaulted, she was never delinquent, and under the Statement of Financial Responsibility, unless Wellington has a patient or consumer in arrears, it simply has no contractual basis for recovering fees under the SFR from a patient or from a consumer. And I would just mention with respect to the SFR, there was an invitation to give effect and purpose to the language of the SFR. It's about money. And that's an invitation to read that contract very liberally. I would encourage the court to decline that invitation because we must construe this contract strictly. We must at least construe the attorney's fees provision strictly. As one example from our brief, the Diamond Aircraft Industries case, a Florida Supreme Court case cited at page 14, it emphasizes that courts must strictly construe attorney's fees and statutes because fee awards are in derogation of the common law. Fees should be denied in close cases, and any ambiguity in the contract should be construed strictly against the drafter. Here, we must strictly construe the SFR for two reasons: because of the attorney's fees provision, and also because Wellington is the sole drafter of this contract. The second reason Wellington has no contractual entitlement to its attorney's fees is because Ms. Hutchings' breach allegations concern the breach of an entirely different agreement, and that's the client's rights document, essentially a patient's bill of rights.
The appellant brought up the fact that your client filed the amended complaint and attached the SFR or based her attorney fee claim on the SFR. Are you estopped or not?
We are not estopped, and there are a few reasons. One reason we are not estopped is the trial court's granting leave to file an amended complaint is not the successful maintenance of a position, and our subsequent inconsistent position on attorney's fees from a judicial and equitable estoppel position is that this is strictly a matter of law, strictly an issue of law, and both parties had the same access to the relevant facts here. Again, we did not successfully maintain a position merely because we filed an amended complaint. This is completely distinguishable from the Philip Morris case, in which the important argument that was advanced put the plaintiff in a position to secure a great deal more money through the verdict, and an inconsistent position was taken later. With respect to the estoppel argument, I wanted to flesh out what successful maintenance means in this district. It requires that the prior inconsistent position have been adopted by the trial court as part of an initial ruling or a final disposition of the case. And this court's decision in the Brown and Brown case addresses that point, as well as the Bloomberg versus USAA case. Hutchings alleged that she would be entitled to attorney's fees pursuant to the Statement of Financial Responsibility if she prevailed, and she was required to do this at the pleading stage, or she would have waived that claim. As we know, the claim for attorney's fees was not tested. She voluntarily dismissed her complaint, and this allegation therefore does not implicate either equitable or judicial estoppel. I want to briefly return to the Pastina case and just point out that the Pastina case, both dissenting opinions may expand the reciprocal rights of the non-drafting party, extending the entitlement to attorney's fees for any action taken with respect to the contract. But that benefit belongs only to the consumer, only to the non-drafting party, and that case concerned whether to award fees under subsection 7 to a consumer. Wellington is here saying, we are the consumer, essentially. We are like Ms. Pastina, and that's simply not the case. We've heard about the jerk machine case. There are a variety of other bankruptcy cases cited by appellant, like In re Moji or In re Navabi. And in each of those cases, as well as the Subway restaurant case, Subway restaurant versus Thomas, the Anderson Columbia case versus the Florida Department of Transportation, across all of these cases, there is one consistent fact, and that is the court is evaluating a fee award for the only party who can benefit under 57-105, the other party. Here, Ms. Hutchings is the other party. Wellington is the party that drafted a one-sided right to attorney's fees, and it is not entitled to the benefits the legislature intended to confer through that statute. With that, Your Honors, unless you have specific questions, we would relinquish the rest of our time and rest on our written submission. Thank you.
Thank you.
Two quick things. First, as to the statute. Again, it depends where you fall with respect to, and I think I must have said Platina half a dozen times. My apologies, I don't know why I did that, but whether you fall on the majority or the minority view. If you fall on the majority view, then Judge Evander, I think you're right. I mean, that is their effort to keep the playing field level by construing the statute, I think, really trying to force that square peg into a round hole, but construing the statute the way they did. If you come down on the minority side, though, I think you have to conclude that if the other party, the non-drafting party, is permitted to assert a claim for attorney's fees on some basis other than that set forth in the contract, then once that door is opened, it's open for everybody. It's the only way to legitimately construe the statute in that context and to keep the playing field level. The only way. Secondly, with respect to the estoppel argument, I do just want to touch on the Nabavi case, another bankruptcy case, actually a district court decision from an appeal of a bankruptcy case from 2014. This was an interesting case because debtor files bankruptcy, bank has a judgment against the debtor, bank moves to dismiss the petition in bankruptcies having been filed in bad faith. Only attorney's fee provisions in a note and mortgage, doesn't have anything to do with dismissal of a bankruptcy case. Both parties ask for attorney's fees. The bank goes to the motion to dismiss hearing, having not withdrawn its claim for attorney's fees, and loses. At that point, they withdraw or attempt to withdraw their attorney's fee claim, asserting that it was a rookie mistake inserted by an inexperienced attorney, and it's not what they really intended. The bankruptcy court and the district court concluded that judicial estoppel prohibited them from taking that position. Specifically, the court said that Centennial's failure to bring the error to the court's attention at the beginning of the hearing on the motion to dismiss suggests that the request was only withdrawn because appellant lost the motion to dismiss. If, as counsel for appellant claims, she discovered the error while preparing for the hearing, she could have alerted the court to the error immediately, either by filing withdrawal on the record or withdrawing the request orally at the very outset of the hearing. There is no legitimate excuse for failing to do this. Accordingly, whether it was a mistake or not, appellant opened the door to an award of attorney's fees and cannot close that door just because the fees are being awarded against it. Thus, the reciprocal fee provision of Florida Statute 57.105 was a sufficient basis for an attorney's fee award here based on the mortgage agreement. This analysis was based on judicial estoppel. Centennial Bank had not received any benefit, anything positive from going through the process, yet the bankruptcy court and the middle district court judge concluded that judicial estoppel nevertheless applied, and that once that door was opened, they couldn't close it once they'd lost. That's exactly what happened here. Thank you for your time, and if you don't have any questions,
Thank you both. It's
I'll wish you a nice afternoon.
interesting and well-presented case. Thank you both.